Can the government put out Christmas decorations to celebrate during the holiday season? Or does this violate the Establishment Clause of the First Amendment of the US Constitution? This seemingly simple question may actually be very difficult to answer. Merry Christmas, Happy Holidays, welcome to the Fox Hollow. My name is Skylar and this is the show Legally Drunk, where I, a lawyer, get legally drunk and rant about the law. This evening we are actually having something called ginger beard spiced stout, and this beer actually just tastes like a gingerbread cookie, so it's a little weird, but I kind of like it. It's very festive though. That's the important part. So, every month I do a special video on old court cases that give me horrible flashbacks to when I was in law school. And this one is no exception. But before we get into these court cases about Christmas creches, nativity scenes, menorahs, and all of that stuff, please subscribe to the channel, like this video, and share it with your friends. I really appreciate getting the word out there about, I don't know, this dorky legal stuff. So, serious question, what kinds of decorations can the government put up, or what kind of decorations can they not put up to celebrate for the holiday season? Well, in 1984, the city of Pawtucket had a city-sponsored creche in a public park surrounded by a Christmas tree, a Santa Claus house, and cut-out figures of a clown, a dancing elephant, robot, and teddy bear. Of course, there were no robots or reindeer in the original story of the birth of baby Jesus. So, in the case Lynch v. Donnelly, in a 5-4 ruling, the court found that the nativity scene did not violate the Establishment Clause of the US Constitution. They based this decision on a test created in the 1971 Lemon v. Kurtzman case. They ruled that the nativity scene was a passive representation of religion, and that there was insufficient evidence to establish that the inclusion of the creche is a purposeful or surreptitious effort to express some kind of subtle governmental advocacy of a particular religious view. They also stated that the Constitution affirmatively mandates accommodation, not merely tolerance of all religions, and forbids hostility toward any. O'Connor, in a concurrence with the decision, put special focus on the endorsement test. A law which fails this test is found to be unconstitutional because it endorses religion or religious beliefs in such a way that it tells those who agree that they are favored insiders and those who disagree that they are disfavored outsiders. On the other side of the coin would be the disapproval of religion or religious beliefs in such a way that those who agree with the beliefs are told that they are disfavored outsiders, while those who disagree with the beliefs are told that they are favored insiders. And remember, our country was founded on the premise of religious freedom. And the whole point of the First Amendment is to make sure, well, not the whole point, but a big point of the First Amendment is to make sure that government is not endorsing one single religion, but also to make sure that the government is not oppressing people for their religious beliefs. So the dissenting opinion argued that the case did not pass the Lemon test and that the secular display with secular purpose of celebrating a national holiday could have been done without a clearly religious symbol that supports only one religion to the exclusion of others, giving one group public approval of their views. Okay, so you may be thinking, case settled, right? Well, no. No, we're far from done. So we will drink to Supreme Court shenanigans. Okay, so in 1989, in Allegheny County v. ACLU, the court decided 5-4 the other way on the creche scene. In this case, there was a nativity scene on the main staircase of the county courthouse. The privately owned creche, accompanied by Santa, dancing elephants, and a banner which said, Gloria in excelsis Deo, glory to the God in the highest, was religious and violated the US Constitution's Establishment Clause. But in the same case, a 5-4 majority found that a nearby display featuring an 18-foot Hanukkah menorah placed next to a 45-foot Christmas tree did not violate the Establishment Clause. Are you following? It just seems like the tree somehow canceled out the religious superpowers of the menorah and the nativity scene, but we'll see if we can piece together some kind of understanding of what's acceptable and what's not acceptable. We're trying. So, okay. After the courts put heavy emphasis on the other symbols scattered around religious displays, you may think the religious display would be saved by things like reindeer, robots, or it seems more consistently, the ever-infallible Christmas tree. Yes, interestingly enough, the Supreme Court has determined that Santas, elves, reindeer, Mrs. Claus, etc. are secular as opposed to religious symbols. Creches like nativity scenes and menorahs are clearly religious, although Justice Brennan tried to point out for the dissenters in Lynch that the religious symbolism is in the eye of the beholder. Yet this distinction lives on. And I think that Justice Brennan has a point here. Like, if you think about a Christmas tree, like, some people would probably say a Christmas tree is Christmas, is it not purely religious? Other people would say that it's secular. And some people would say, well, it's religious, but more for like, winter solstice. Maybe it's a pagan symbol. So those are all questions, and it's not exactly clear to me anyway. Like, some things I think are clearly religious, like a nativity scene seems to be clearly religious. A menorah seems to be clearly religious. But the Christmas tree is like a big question, and it's funny to me that it seems to have this special power to basically negate religiousness, maybe, but we'll see some inconsistencies in a little bit. So yeah, the Christmas tree itself is not only determined to be secular and constitutional, but its proximity to those other items seems to save the religious symbols that would be unconstitutional if standing alone. Except in a moment we will see a situation where there was no Christmas tree involved. So I'm not sure. Another consideration is that government-sponsored displays are more constitutionally suspect than private displays in public places, although that did not save the nativity scene in Allegheny. If the lemon test wasn't enough for you, here's another. The reasonable observer test. The test devised by the Supreme Court in the Establishment Clause cases is simple. Would a reasonable observer of the display in question believe, even mistakenly, that the government was endorsing a particular religion or religious viewpoint, or religion in general? There is a sharp divide on the court between the justices who assume reasonable observers understand the history and context of the public space and are aware if it's open to all people, and the justices who feel like reasonable observers may just be visiting and not understand any of the context surrounding any of the decorations or the public space at all. So signs posted around the display are also important. The court has, of course, we saw it, they frowned on Gloria in excelsis Deo, but they've been just fine with things like Happy Holidays or Salute to Liberty. And a sign indicating that the display was sponsored by private parties goes a long way to curing the impression that the government has endorsed it. Okay, so now that we've cleared that up a little, how consistently is this enforced by the lower courts? And how helpful are these bright guidelines? Okay, they're not so bright, are they? Yeah, not very. Because the court did not give very good guidelines, we don't have a good precedent on this either. Zoe! Really? Really? I just don't even wanna fix it. I don't, oh my gosh. Okay, so to give some examples, a Court of Appeals decision in Jersey City, New Jersey decided that a creche and menorah display was not constitutionally cured by the city's addition of a plastic Santa, a plastic Frosty, and a red sled. Okay. They didn't have a Christmas tree. That's what the problem was, right? In 1997, Syracuse, New York, a court of appeals found that a city-owned creche display was constitutional, as was a privately owned menorah display, even though the two were displayed in totally different city parks. And there didn't appear to be any Christmas trees involved. Okay. A lawsuit in Madison, Wisconsin involved the city's refusal to allow religious-themed ornaments to hang from the secular Capitol holiday tree, which, may speak to hostility towards religion. And when I was trying to figure out what happened in that case, I came across a recent article about a different political Christmas tree dispute in Wisconsin. We're gonna spill the tea on this one. Earlier this month, Wisconsin Governor Tony Evers said the state tree would not be put up in the Capitol building due to the pandemic and the building's closure to the public. But there are still people working in the building, senators and such. And so two Republican lawmakers, Paul Tittle and Shay Sortwell, put up their own Christmas tree in the Wisconsin state capitol. But then their tree was removed. But never fear. They had a backup tree, which they put up hours after the first tree was removed from the rotunda. Representative Tittle received ornaments from all over the country to add to the tree and plans on donating extra ornaments to nursing homes in his district. He said the tree is artificial, doesn't cost anything, doesn't see a problem with it. The lawmakers have also applied for a permit to have the tree there. You need a permit to put up a freaking Christmas tree anymore. That's government regulation for you. All right, he said that if this new tree is taken down, additional trees will be supplied. Maybe by Christmas, they'll just have so many trees just hanging out in the rotunda. Wouldn't that be fun? I like Christmas trees, so I think that's cool. So now we're not even fighting about religious symbols next to Christmas trees or without Christmas trees. We can't even put the damn Christmas tree up because of COVID. Oh my gosh. Check out my video about worshiping during a pandemic. I'm very frustrated with governments locking down, not allowing people to practice their religions together. That to me just seems like total infringement on your First Amendment rights. Is not even a question. Here's my opinion. As long as the government isn't explicitly endorsing any one religion or disenfranchising practitioners of any religion, I don't have a problem. For instance, banning the word Christmas or prayer or wearing religious garb of any kind, like a cross necklace or a yarmulke or a hijab, that disenfranchises people from practicing their religion. I've got a major problem with that. I've got a major problem with governments not allowing people to practice their faith in a public, well, it's not a public setting, it's private, it's a church. But they can't worship together. And even when they're singing outside, go check out that video. Do I care if there is a menorah or a nativity scene around town? No, I don't care. It doesn't offend my sensibilities, and it doesn't seem like the kind of establishment that the founders were concerned about. And I actually really love holiday decorations, if you couldn't tell. So I think it's really festive to have holiday decorations up around this time of year, and I don't want to discourage governments from not putting out holiday decorations. I think that's just really sad. So what do you think about these court cases? Let me know in the comments section down below. And if you've made it this far, please consider subscribing to the channel. Like the video, share it with your friends, and from me to you, a warm, happy holidays. Cheers.